we're going to dive right in to the Alabama redistricting case.
Yeah, this is like a porterhouse.
Okay.
You know, this is like one of those steaks that if you eat it all in one sitting, you don't eat steaks again you don't have to pay for a steak for a year. That kind of steak.
Unlike the Supreme Court, which I think based on this opinion is going to be wading into a lot more Voting Rights Act cases. So I hope they like porterhouse.
Yes.
All right. Let me just set this up for everyone. Alabama in the 2020 census had a 5% growth in population. Not enough to change the number of congressional districts that they have, but enough that it changed some of the balance of where population growth was. They have 7 congressional districts. The Black population in the state is 27%. The voting age Black population of the state, 25.9%. So not that big a difference. And the question was, does Alabama have one majority Black congressional district, or does it need to have 2 majority Black congressional districts under Section 2 of the Voting Rights Act? So let me just read you Section 2 of the Voting Rights Act. No voting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied by any state or political subdivision in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color. A violation of that is established if, based on the totality of circumstances, it is shown that the political processes leading to nomination or election in the state or political subdivision are not equally open to participation by members of a class of citizens, in that its members have less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice. The extent to which members of a protected class have been elected to office in the state or political subdivision is one circumstance which may be considered, provided that nothing in this section establishes a right to have members of a protected class elected in numbers equal to their proportion of the population. So I know that that's a little dense, but you've got a bit of a contradiction built in here. On the one hand, it's saying that you need to have equal opportunity to elect representatives of your choice. On the other hand, they're saying this is not a quota system or a proportionality test. So how do you know? Well, here we are. It's been a while since the Voting Rights Act was passed.
Yeah.
And we don't have a great answer to that. Some of it is based on the Jingles test. Now, that is spelled Gingles. And speaking of pronunciation, David, there's disagreement even among the justices of whether it's
really
Jingles or Gingles. Justice Alito has been pronouncing it Gingles. But I want to say I'm very grateful to those at the Gaston Gazette of North Carolina, when in fact, Chief District Court Judge Ralph Jingles Jr. died in 2015. They published a very lovely story on him. And this is one of the lines. Known to his friends and colleagues as Skip Jingles, parenthetical, pronounced Jingles with a J. Born and raised in Gaston County, he was the named plaintiff in that case who goes on to become a judge, etc. So done. We're done with this. It's Jingles.
So say goodbye to my preferred pronunciation of Gingles.
All right, let me run through the jingle standards. Gingles. All right, a little punchy today. First, the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district, i.e., if you have, I'm going to use Texas as an example here. If you have a large population in Houston and El Paso, but neither one is large enough to form its own district, you're not going to be able to do a district then because you can't connect Houston to El Paso. So that's the end of the ballgame. That's the first Jingles test. Second, the minority group must be able to show that it is politically cohesive. I think this is actually a pretty interesting test in Texas, for instance, where in the Texas 23rd District, which is a majority Hispanic district by population, they elected, Will Hurd, who's half black and half white, for several terms. So that would be not politically cohesive in that sense. But Alabama's kind of different on that front, which we'll get. Third, the minority must be able to demonstrate that the white majority votes sufficiently as a bloc to enable it to defeat the minority's preferred candidate. Finally, a plaintiff who demonstrates the three preconditions must also show, under a totality of the circumstances test, that the political process is not equally open to minority voters. All right, David. So the question in this case was, is jingles still good law? Or are we tossing that out and instead moving to something more like a race-neutral test, i.e., as long as Alabama wasn't preventing the creation of a second majority black congressional district because they wanted to prevent, a black majority congressional district for race reasons,
right,
then maybe you're just fine. Like it's going to be really reminiscent of the affirmative action conversation. Is race neutral enough? Or in fact, are you supposed to be race conscious and race helpful? And we talked about this during the oral argument. And David, I never remember what we say or predict, but a listener sent us notes and said that you had actually nailed it. You predicted that Brett Kavanaugh would side with the chief and the three liberals, striking down Alabama's single black congressional district map in favor of a two-majority black congressional district map. I was like, wait, he did? That was prescient? Because that's exactly what it ends up being. Kavanaugh does have his own separate concurrence. We've got some dissents, but this is Kavanaugh, the chief, Jackson, Sotomayor, and Kagan saying, yep, jingles is good. And this current iteration of only one black majority congressional district violates the Voting Rights Act.
Yeah, I did not remember getting that right either. I did not remember. But I did remember, because there's been a lot of podcasting water under the bridge since that oral argument. But I did definitely remember leaving the oral argument and I remember talking about the oral argument. Like, I don't know that this is going to break out the way everyone was assuming this was going to break out after listening to the oral argument. And, Sarah, there's some big picture stuff here before we dive into the details. And here are two big picture points I want to make that I think are going to be relevant to the rest of the discussion. So one of the big picture things is it goes to the very beginning of the opinion where Justice Roberts points out that for the first 115 years after Reconstruction, there was not a black federal representative elected out of the state of Alabama. So you have a situation that fact bleeds into big point number two. You have a situation right off the bat here, Sarah, that starts to distinguish it from like the Harvard and UNC cases. Because if you remember, the Harvard and UNC cases, the schools had not said, hey, we're doing affirmative action to address past racial discrimination. That is not the argument that has sustained affirmative action. It is, we are doing affirmative action and engaging in race-conscious admissions decisions so that we can ensure diversity, which is not the same thing as saying we're correcting past racist actions. If you had a policy that said something along the lines of a person who can establish that they were a descendant of enslaved individuals receive some sort of tuition break or whatever, that would be something that's more directly related to past racial misconduct. So that fact, the 115 years, and let's think about this. It wasn't until the early 90s that Alabama had elected a Black representative. That's a remarkable statistic given the percentage of Alabamians who are Black. And so this automatically and immediately takes us a little bit out of the Harvard, North Carolina paradigm, which I think is really important when we get to, say, the dissent, for example. And so this is not a case like a Harvard or Yale where you're saying, hey, diversity, look, there's historical injustice we're trying to correct, which gets to the purpose of the Voting Rights Act. So those are a couple of big observations before we dive in.
Yeah, look, here's some big questions that I think come out of this. A, what does it mean for the Harvard case, if anything? And I sort of hate this game because, frankly, Harvard's going to come out in 3 weeks or less. And why sit here and guess? But we're going to do it. Don't worry. We'll do it. 2, what does this mean for future redistricting cases? And in particular, we know the court's already accepted another case out of South Carolina for the fall. And 3, I do want to talk about, and I talked about this with the oral argument, right? The reality of redistricting fights. And let me actually start with that before we dive in a little bit more into the opinion, because I think it's going to inform my take on this and why I so strongly side with the dissent. While thinking, by the way, that Alabama's history here is pretty bonkers. For instance, the district court noted that on average, Black voters supported their candidates of choice with 92% of the vote, while white voters supported Black preferred candidates with 15% of the vote. Yikes. The racial polarization voting in Alabama is intense, very strong, and very clear. That's very different than my experience working in politics in Texas. I've never run a race in Alabama. So take all of that to understand where I'm coming from as a former political operative. But here's how this looks on the ground. And I talked about this before, right? There's packing and cracking. Packing, both of which are not allowed under Section 2 of the Voting Rights Act. Packing is when you intentionally put a racial minority into as much of few of districts as possible, as in you pack them in to minimize their political impact in the state. So, making sure that it's an 80% Black district instead of 40% Black districts. That would be packing, and that would violate Section 2. Cracking is when you intentionally break up a minority group into smaller pieces to also minimize their political impact then in the district and the state. So there's a, neighborhood, let's call it, that's 80% Black, rather than put them all in the same congressional district, you're going to break that up into 5 congressional districts that are going to be pie pieces, so that the pie originates in the center of that neighborhood. And therefore, each congressional district only has, a 20% of that neighborhood. So that community doesn't really get to pick anyone. Also violates Section 2. And so the result in a modern political sense is that you're going to have some people who want to strike down districts as cracking and packing, and some who are going to want more cracking and packing, but the kind that's legally mandated instead of the kind that's legally prohibited under Section 2 because of which of the types of preferred candidates within those factions within a political party are favored. And it's a mess. And it's part of the mess when you intentionally insert race into a consideration instead of having or allowing even race-neutral criteria. But David, this is where you sort of have 2 different legal philosophies hitting each other. On the one hand, you can argue, we should have race-neutral criteria. And on the other hand, you read the text of Section 2 of the Voting Rights Act, and it clearly was not meant to be race-neutral. And so are you a textualist or are you a race neutralist under the Constitution? And that's where the dissents are going to get interesting for me. So those are my big picture questions heading into this.
I've got one other big picture observation, and this is related to a very controversial previous ruling from the court. And this is the Shelby County v. Holder decision from 2013, which basically took the old ejected the old pre-clearance requirements under the Voting Rights Act, where you had certain states in the old Confederacy that they had pre-clearance requirements for voting, right? Legal changes that would impact voting rights. And so the argument was essentially, wait a minute, okay, you can't forever hold these particular states apart from the rest of the union and apply heightened degrees of scrutiny to these particular states. Sarah, I have a thought here that this case essentially overrules Shelby County through the back door in an interesting way. Not in a pre-clearance, not the pre-clearance aspect, but what it does actually do is, because of the unique nature of the states that are likely to be implicated by this decision, you're going to end up with a situation where some states are going to have different kinds of scrutiny. So let's take your Texas example. Let's leave Texas aside. It's a little more complicated because its demographics have changed a lot. If you're going to say, look at California, you don't have the kind of racial polarization in voting in California that you do in Alabama or Mississippi or even Tennessee. Your white voters are going to be much more Democratic. Your black voters are also going to be quite Democratic, but you're not going to see that sharp racial polarization. Even if you go to New York, your white voters are going to be more Democratic than white voters in Tennessee or Alabama. You're not going to have that racial polarization in voting. Where are you going to have that extreme racial polarization in voting? It's going to be disproportionately in the old pre-clearance states. So this isn't a pre-clearance, obviously, because this isn't the same. This isn't the exact same situation where you have that kind of pre-clearance. But I think it's a practical matter when one of the big factors is going to be what is the racial polarization of the voting. That's going to really only come to bear in a limited number of states. And hopefully as America progresses through and hopefully as America progresses through and past centuries of racial polarization, fewer states will be in that category. But for right now, you're looking at a lot of the old pre-clearance states that are going to be the ones that are going to be most impacted by this analysis because of the racial polarization of the voting that is not universal in this country.
All right, let me walk through a little bit of the opinion. The Chief Justice wrote the majority opinion, and then we have a Thomas dissent, which is fascinating, and an Alito dissent, which is actually quite restrained, I thought, given what we've come to expect. So in the majority opinion, you're going to have the plaintiffs on the one side arguing very simply that they just meet each of the Jingles tests, factors, and that Jingles is still good law, therefore they win. So the Black population is compact enough to form a second district. They provided several maps that did that. They're politically cohesive, as we saw with that statistic, about 92% voting for their candidate of choice. They are also then being blocked by the white majority, as we saw, where the white folks are only voting 15% for that candidate. And that under the totality of circumstances, the political process is not equally open for lack of that second majority-minority congressional district in Alabama. Alabama, the state, on the other hand, was arguing that basically what Section 2 of the Voting Rights Act prohibits is obstacles or burdens that block or seriously hinder voting on account of race, i.e., where a map that never took race into account is being proffered, it can't violate Section 2 of the Voting Rights Act. If you took race into account, maybe so, but Alabama says they didn't. And in fact, there was just the battle of the computer algorithm experts with Alabama saying, look, we put together 1 million maps not using race, and none of them had a second majority Black congressional district. Whereas the plaintiffs put together maps, and all of their experts said, yes, of course we took race into account in order to make the second majority minority district. That's what Section 2 both allows and requires. Okay, Alabama also argued that Jingle should be overturned basically because it ends up requiring racial proportionality in districts, those factors that we just talked about. That basically where another majority Black district could be drawn, it must be drawn. And that's a proportionality problem that Section 2 prohibits. And remember, you've got the text of Section 2, and then you've got those jingles factors. So if there's a gap between them, Alabama was trying to squeeze in and say, you need to side with Section 2, not with jingles. And that, Section 2 is this compromise that Congress struck. The Chief Justice walks through the history of Section 2 in this opinion. I thought it was the best part of the opinion. It was fascinating to walk through some of that legislative history. But legislative history is a bit of a triggering word for conservatives. Here, however, though, that legislative history goes to the very text and informs the very text of how that came about, how this log rolling and compromise happened. It was really fascinating. So basically, the Chief Justice saying, look, jingles is still good law. The race-neutral approach doesn't work because that's not what Section 2 requires. The end. And then there's a part that is the plurality opinion for the court. There is a difference between being aware of racial considerations and being motivated by them. Why is this only the plurality? Because Brett Kavanaugh did not join that part. And David, I'm going to say it one more time. There's a difference between being aware of racial considerations and being motivated by them. What? What does that mean? Huh?
Yeah.
How are lower courts supposed to know the difference between...
I read that part of the opinion. Yeah. I read that part of the opinion 3 times.
Me too. Couldn't do it.
And I couldn't quite get it.
Nope.
Yeah. Mm-mm.
And remember, I wasn't even drinking on my vacation. So I was sober while trying to read that. So look, Brett Kavanaugh's not going to join that part, which is really fascinating for a lot of reasons. So then we're going to move to his concurrence, which is all about stare decisis. And this will have, I think, the biggest implications for future Kavanaugh watchers as he is the swing justice on the court, which is he says there is a difference between stare decisis for statutory precedent and constitutional precedent. So, for instance, with constitutional precedent, nobody can overturn that. Once the court says this is what the Constitution says, like you're done. And so he says stare decisis then shouldn't have as much weight because if the decision was wrong about what the Constitution said, the only people who can fix that are the Supreme Court justices. And so precedent should be weighed against that truth about constitutional stare decisis. Statutory precedent, on the other hand, Congress, I'm reading now from his concurrence, Congress and the president may enact new legislation to alter statutory precedents such as jingles. In the past 37 years, however, Congress and the president have not disturbed jingles, even as they have made other changes to the Voting Rights Act. Although statutory stare decisis is not absolute, the court has ordinarily left the updating or correction of erroneous statutory precedents to the legislative process. What say you, David, about the distinction?
Look, okay, so let me just say this. I am becoming a real fan of both the Kavanaugh and Gorsuch concurrences.
That's exactly what I was going to say.
For different,
oh my gosh.
For different reasons.
Yes, for different reasons. But I'm so into both of them. It's like one of those teeny bopper movies where the two lead males are totally different and you're supposed to pick which one you have the crush on, like Hunger Games or Twilight or something. I know Hunger Games. I'm less sure about Twilight. But yeah, like I'm so into both. Okay, good. I'm glad you agree.
Yes. Oh, the hive mind at work. But what I like about the Kavanaugh is always like, this is a really big controversial thing, but here I am to sort of say it's a lot more simple and less controversial than you might think. And he kind of you can tell he's kind of got this chilling out vibe about it. And the thing I liked about the concurrence was, number one, like a lot of the Kavanaugh concurrences, it's very readable and it's very direct. And also it really lets you in on his thought process. So on the statutory precedent versus constitutional precedent, I found that pretty persuasive, honestly. But then he goes on, and I don't want to get ahead of you too much, Sarah, but he talks about the reasoning here, the steps. He goes through the steps in a way that was simpler and easier to understand than the Roberts majority opinion, and helps you kind of reconcile the racial element of it as well in a way that the Roberts majority opinion didn't really do it. And I thought he made it much simpler. He said, Jingles requires the creation of a majority-minority district only when, among other things, although I love that phrase, only when, among other things, a state's redistricting map cracks or packs a large and geographically compact minority population, and 2, a plaintiff's proposed alternative map and proposed majority-minority district are reasonably configured, namely by respecting compactness principles and other traditional district criteria such as county, city, and town lines. So that makes it a lot simpler in my mind, Sarah. Look, if there's a geographically compact minority population and you crack it or pack it, and then there's an alternative that recreates a majority-minority district that's reasonably configured, boom, we're in Jingles territory. That I can understand. That makes a lot of sense, because what it is saying in essence is, okay, wait a minute, we're not going to come in and require proportional representation when, say, for example, minority voters are sprinkled evenly around the map, and you have to do the crazy, wild things that Roberts talked about.
The dragon districts.
Basically got a district that, yes, a hydra, a dragon, whatever you want to call it. And the way Kavanaugh did it, it just makes a lot of sense. Here's the simple 2-step process. It provides litigators a roadmap. It doesn't get into the difference between race consciousness and race motivation, which I still don't know what that is. So I was a huge fan of the Kavanaugh concurrence, such a huge fan that really I feel like you can read just the concurrence and almost have a better sense of what's going on than from the whole majority opinion.